Welcome back to Christian Culture, the podcast by Lutherans and for Lutherans and anyone else who will listen. Brought to you by Luther Classical College in Casper, Wyoming. Lutheran, conservative, classical, a college for Lutherans and by Lutherans with classes starting fall of 2025. We're talking today about the overturn of Roe versus Wade and what it means for our nation and our states. And first of all, it's time to be rejoicing. Thank God. We've prayed for this for 49 years. It's interesting that I can say that because I'm not 49 years old, but I have joined the communion of saints. And that means that my prayer has been joined with the prayer of those who have gone before me, the democracy of the dead, for 49 years. And this is a time of rejoicing, and we should take the time actually to rejoice. God wants us to. He just gave us what we asked for, and we asked it in Jesus' name, and it is a good thing, and he loves to see us thankful. So if you haven't actually had a party and a celebration, you should do it. You should uncork the champagne or the equivalent and rejoice in this decision that God gave. And then the other thing that comes with rejoicing is that when God answers our prayer, it is also an invitation to keep on praying because he wants to keep on giving us good things. And so we do want his will. We want good things. We want babies saved. We want mothers to love their children. We want fathers to actually take care of their children and take care of the mothers of their children. And we want people to know the God who instituted marriage and family. And this is love of God. It's love of our neighbor. And now is the time to redouble our prayers to God for our individual states, for our individual cities and the families in our communities. It's not a time to just rejoice and then stop praying because we got what we wanted done. We need good leaders. We need good governors, judges, and magistrates in our own states and in our own cities. So to inform our rejoicing and our prayers, we have a new guest, Pastor Jonathan Lange of Evanston, Wyoming. He's the marriage, life, and family facilitator for the Wyoming district of the LCMS. He has a passion for the pro-life issue and pro-family issues, and his passion is contagious. And he's inspired me and a lot of other pastors here in Wyoming and across the nation to take more seriously involvement in our community, especially when it comes to these life issues. So thanks so much for being with us, Pastor Lange. Welcome.
I'm so happy that you called and let me on. I can't wait to talk about this stuff.
Excellent. That's my Luther Classical College mug, by the way. I hold it this way. You can't hold it by the handle, but then if I did that, you wouldn't be able to see it. So I do this on purpose so you can see my Luther Classical College mug, and you can go on our website, lutherclassical.org, and order one for yourself. Okay, so first, we've heard a lot about... No, that's not first. First, could you give us a short review of what the Supreme Court just did in Dobbs versus Jackson?
So Dobbs versus Jackson was decided by a 6-3 margin. And I want to talk about that. Before I get to that, though, something that nobody's saying, and I think we ought to say very clearly, that on the most salient issue, it was 9-0. That is just incredible, and I think it needs to be said over and over. And that is that even the liberal dissenting justices, all of them agreed, quote, now I'm quoting from the dissenting opinion. It said that it says, in 1868, and I would just add no time before that and no time after that until 1973, there was no nationwide right to end pregnancy and no thought that the 14th Amendment provided one. That's agreed upon by all 9 justices. And so when people get online and start saying stuff like, this was closely decided and this is still a constitutional issue, they all agree that there's nothing in the Constitution about this. Pretty much the whole thing was about stare decisis. So let's talk about that. So there were 6-3. The opinion was actually 6-3 to uphold Mississippi's Gestational Age Act. Okay, so what the Gestational Age Act is it was legislation passed in Mississippi which forbids abortion after the 15th week, except for the life and health of the mother, which is standard language, which was before Roe v. Wade all across. When they passed that legislation in Mississippi, they knew that it was going to lead to a Supreme Court review, because the Supreme Court standard, going all the way back to Casey, was viability, however you define that, generally between the 21st and the 25th week. So they were going to challenge that by 10 weeks. And what the majority opinion, together with Thomas and Kavanaugh, and even Justice Roberts, all of them clearly said that the viability standard is bunk.
Wow.
That it is, it's unworkable. It can't be handled. So I think I'm reading here from Roberts. He said, only a handful of countries, and among them China, North Korea, permit elective abortions after 20 weeks. The rest have coalesced around a 12-week line. So let's see.
Well,
so the court rightly rejects the arbitrary viability rule today.
Wow. And that's the arbitrary viability rule comes from Roe, not Casey, right?
Kind of. What happened is that Roe made up a new 3-trimester scheme. And so they split it into 3 trimesters, and they said that the government has no business messing at all in the first trimester. There may be some reasons for the health of the mother in the second trimester. And the only time that the state has an interest in abortion is in the third trimester, because that's generally when viability occurs. 20 years later, when that was challenged in Casey, they deleted the trimester scheme and zeroed in just on the viability line, and moved it. So they moved it from the third trimester to more like 24 weeks or something like that. And on this case, now they've just obliterated it altogether. At least
How interesting too that the judgments that you were just quoting from cite North Korea and China, totally repressive communist states. And they say that the general agreed upon line is around 12 weeks in Europe and so forth, in developed countries.
Yeah.
And yet the Mississippi law was only going for 15 weeks. And I mean, that's a more liberal law than what you find in Europe.
Yeah, that's right. And still, even with the overturning of Roe, America's abortion laws are more liberal than most of the world. Yeah. So we still got work to do.
Yeah, absolutely.
Yeah. So let's move on to the next number. We said 9-0, and then we talked about the 6-3. But in fact, the overruling of Roe was a 5-4 decision. Roberts pointedly checked out of it. And the interesting thing is that both the state of Mississippi and Jackson Hole Health stipulated in their, I forget they're called, in their filings, that the only possible way, there is no possible way to decide this one way or the other. That is to throw out the viability or to keep the viability without also throwing out Roe v. Wade and Casey or keeping Roe v. Wade and Casey. They both admitted that. And this is what Roberts, he tried to play the middle ground and tried to throw out viability without throwing out Roe v. Wade or Casey. And just nobody followed him. Just because it's a ridiculous standard. You just can't go there. So it was, in the end, it was 5-4 to overturn Roe. And what they did is, first of all, as we've been talking about, they threw out this the central holding of Roe. That's the way Casey put it, and that is, quote, that a state may not regulate pre-viability abortions for the purpose of protecting fetal life. And they clearly said, yes, the state has an interest in regulating pre-viability abortions to protect fetal life. Not just, notice it doesn't just say to protect the life of the mother. That was the Roe standard. But now they're saying pre-viability also to protect fetal life. Can I just take a little side note here? On the reasoning of the Gestational Age Act, they gave three things when they wanted to set the 15-week standard. One of them is that abortions at the 15th week and in the month before the 15th week are more dangerous for the woman. So you get the life and health of the mother involved. Mm-hmm. But the other one is that those abortions are generally dilation and extraction, which means reaching into the sanctity of the womb and tearing apart a child limb by limb. Mm-hmm. And they said it's barbaric. Mm-hmm. And then the third thing, because it's so barbaric, it destroys the integrity of medicine. And so they wanted to protect medicine, the baby, and the mother with mm-hmm. this line.
Yes. And you could add protect just society. It's bad for society to even have this around them, to know that it's happening in their midst. It's interesting that as I was reading through the opinion, this was argued when Casey was argued. Both sides tried to say, well, it's bad for society if we don't. So on the left side, they said it's bad for society if we don't let these women kill their unborn children. And the other side said, no, it's bad for society if you allow it in the first place. And the opinion then, Dobbs versus Jackson, Alito makes it very clear that obviously that standard can't be the decisive standard unless we're being totally biased, because we would then have to define what the good of society is outside of the Constitution. Mm-hmm. One thing I wanted to bring up in reading the opinion is that it also asserted and proved that Roe versus Wade was wrong on basic historical points and just factually wrong. And that specifically had to do with common law and what common law had banned, namely abortion. Could you comment on that? Just the incorrect factual, just the factual errors of Roe.
Right. And it was, we find out it was more than factual errors. It was outright lies. So the Roe court relied upon a couple of academic papers that were published while Roe was being decided. So people were trying to influence the court with these academic papers that were not amicus briefs. They were academic papers, and they were propaganda, which deliberately distorted and misstated the historical record. It was a travesty. Since Roe, they have been thoroughly debunked. But we have found, and I think Alito said this in his opinion, is that the historical record actually includes a memo within that was passed among the lawyers of the Roe legal team that admitted that these papers were propaganda and were false, but they used them anyway. Wow. So we have been lied to for 49 years about history going all the way back to the 13th century common law. And so a large part of this opinion written by Alito was simply to correct that historical record. And so he spent a lot of time on destroying the arguments that the Roe court used. And it's funny to me that the three-person dissent took him to task for that and said he spent all this time on the historical record and it was irrelevant to the Constitution. Well, somebody should have said that back in 1973. Yeah. But it's amazing.
Yeah, so this is why, by the way, we want a classical Lutheran college, because this is what they simply ignore history and they denigrate it and say, oh, it's irrelevant, right? We're making our own history. And all of the arguments of the dissenters, of the three, just have to do with how this is going to affect people in our day, right? There's no really constitutional arguments or historical arguments, just, oh, this is going to affect society in a bad way according to our liberal leanings.
Right. And only their liberal leanings are the guiding light. If you put this question about how it's going to affect society before the majority of the American people, they can't have that.
Sure.
Because we won't go along with it. They've never been able to have the majority to convince the majority of America of the right of the position. And so this has been a raw judicial power.
Yeah.
All along.
It's also typical white liberal arrogance that their view of right and wrong is what should be imposed on the whole country because they know better, right? It's this elitism. And if you read them carefully, you actually see that this is what they're promoting. It's for your good, you stupid Wyomingites. It's for your, it's for your good, Mississippi. We know better than you. And if you had gone to our universities, then you would know too. Really amazing, the arrogance.
Right. Well, that leads to the third part of the 5-4 decision. So the 5-4 decision was decided on throwing out viability, on correcting the historical record, and then thirdly on a more careful reading of stare decisis than the Casey court took.
Yeah.
And so they actually defined stare decisis and then applied it with an even hand. And on all three of those counts, Roe had to go.
Yes. So stare decisis, for our listeners, that's Latin. It's horribly pronounced Latin, but that's not Pastor Lange's fault. It's just how we all say it, is stare decisis. But it's in classical Latin, you'd say stare decisis, right? So to stand with what has been decided is the principle of stare decisis. And amazingly, Casey, which upheld Roe 20 years after Roe was decided, Casey, its only reason for upholding Roe was stare decisis. They thought, like, some of the majority, it was a 5-4 decision, I believe, some of the majority thought Roe was wrong constitutionally, but said, well, stare decisis. We got to stand with what's been decided. Like, that is not your job. So Casey is almost even more of a joke than Roe v. Wade constitutionally. And it was if we remember back, listening to how the senators would grill, Kavanaugh, grill Barrett, grill Gorsuch, grill Alito. That was the question they always ask, right, about abortion. And they would always say, well, we believe in stare decisis. We believe in stare decisis. But then you have to define what stare decisis is. And they tried to get into that with Amy Barrett because they asked her if it was super precedent, Roe versus Wade. And she said, no, it's not super precedent. It's precedent. So they were trying to get her to define stare decisis more, to try to, I guess, kind of angle her to show her, to expose her as a radical who might, protect babies' lives. And that's why when you hear these liberals complain, especially the liberal Republicans, like Susan Collins, she'll say, I felt like I was deceived, but they don't say that about Amy Barrett because she was very upfront. She said, no, Roe v. Wade, it's not super precedent. So that's interesting.
Yeah.
Did you want to say something, or should I continue?
I could say one more thing about.
Please do.
Stare decisis.
Stare decisis.
Well, it's just fascinating that Alito kind of rubs their noses in it, that the most important cases that the Supreme Court has decided over the last 240 years have broken stare decisis. And one of the most important was Brown versus Board of Education, which, if it would have stuck with stare decisis, would have kept Plessy Ferguson.
Yeah.
And said, just on the basis of, well, this is what we always said, that separate but equal is a good doctrine. So precisely what the liberals are most, have the most hair on fire about, that would have stayed in place if Casey would have stayed in place. It's just ridiculous.
Yeah, they're total hypocrites. Um, uh, they're fine with the principle as long as it it is to their advantage to follow it, but they throw it out as soon as it's not. Okay, so the next thing we want to talk about is how this is affecting the states. And here in Wyoming and in I think even most other states, but it's a number of states, we have what are called trigger laws, and some are more strict than others. And so I just wanted to give you an opportunity to talk about what a trigger law is, and then also what the kind of different trigger laws are throughout the states.
Okay, so a trigger law, the trigger refers to an event which happens historically, which then triggers the law to go into effect. And in this case, there are 12 states that have passed trigger laws where overturning Roe or Casey is the trigger, which would then put a different set of laws into effect. And there were two types of trigger laws, those that were automatic, where the Supreme Court's decision itself triggered them, and those that required a judgment of either the legislature or the governor or the attorney general. And in Wyoming, ours is requiring the judgment of the governor. So right now we are waiting. We are 4 days into a 30-day period where the attorney general is supposed to advise Governor Gordon as to whether this triggers the law. And then he's supposed to make a judgment. And then from the time that he makes the judgment until the time that the law goes into effect is 5 days. So we've got potentially a 35-day wait before Wyoming's laws are changed. There are some, out of the 12 states that have trigger laws, there are some that have already gone into effect. And those are the ones that have where the opinion itself triggered it, and that have no waiting period. So I think South Dakota, Texas, Kentucky, and Oklahoma are already in effect based on their trigger laws. We should also keep in mind that in addition to the 12 states that have trigger laws, there are also a number of states that passed laws that transgressed the guidance of Roe, and were basically they were laws that were waiting either to be thrown out by the Supreme Court or to be agreed upon by the Supreme Court. And so there are a number of states that already have better laws in place that were not thrown out by this decision, and so they're already in a better position. I
almost wonder, with the,
so I don't have the figures on those.
I almost wonder with Mississippi whether they might just make their law even better now after this win. Because as we said, it was.
Well, I think all of us are going to have to.
It's 15 week. Yeah.
Right. 15 weeks is inhumane. 1 week is inhumane. There's still lots of work to do. We got to chip away at it one at a time. And the great thing about this, before I get down in the mouth about the things that we still need to do, but the great thing about this is that we have had the foot of the Supreme Court on our necks for 49 years, so that every time we try to do something good with regard to abortion laws in the state, there is a huge hammer which is wielded against us, saying the Supreme Court won't let it stand. And so we're not passing the laws that we actually want to pass because we're afraid they'll be knocked down. Well, this decision gets that hammer out of the hands of the opponents. Mm-hmm. And now when we argue in the state, we're arguing on the basis of rational basis and not on the kind of theory of what the Supreme Court will allow and what it will not allow.
Yeah.
So it's going to be a free argument now.
Exactly. And it was so refreshing to see that, what you just said, articulated in the very opinion of the court that overturned Roe. We return this to the states, to democratic process, right?
Yeah.
And And then
Yeah.
just
Yeah.
the beautiful articulation. I mean, reading that opinion, I just hope all our listeners just go and read it, because it's a beautiful civics lesson, on how the nation is supposed to actually
Hmm.
work, and
Yeah.
and what the role of the court is supposed to be. Yeah. So I had a question about some of these trigger laws, some of these state laws. The one in Wyoming, for instance, has exceptions for rape and incest and health of the mother, which are very, very common. The health of the mother is almost always there. And we know the rape and incest um, ones are debated. But I just want to quote from the Wyoming trigger bill, because I'm sure this language is found in other states. And it says this: an abortion shall not be performed except when necessary to preserve the woman from a serious risk of death or of substantial and irreversible physical impairment of a major bodily function, not including any psychological or emotional conditions, or the pregnancy is the result of incest as defined by some Wyoming statute. So the big question I have is, who determines this physical risk to the mother? Does more legislation have to happen in states to sort of like define what this is? Because I can see a doctor, giving a go ahead and saying, "Oh, this could hurt the mother," when it really won't. And then also, who determines when it comes to a rape? Because a woman can claim rape. I mean, look at the Me Too movement.
Mhm.
A woman can claim rape without any evidence whatsoever.
Yeah. Yeah. Well, let me just give you a little bit of history on that language before we talk about how to adjudicate it. Um, the first part of that language that you read was basically carried over from our law pre 1973. It was slightly modified through the auspices of some nationwide pro-life groups that vetted it, and especially the addition of the laws not to include mental harm and these kinds of things. So that has been standard abortion law going all the way back to when Wyoming was a territory. Abortion laws going back into the 1800s always included a provision that if it was a choice between the mother's life and the baby's life, that is an area of morality that each person has to deal with. And I think there's some truth to that, simply because giving up your life for the love of the brother is by definition a voluntary act and not a coerced act. But now to your real question: who decides, and is it possible for a physician to just sign off on an abortion when it actually is not going to cause bodily harm to the woman? I think that the reason that the pro-life groups across America generally agree to this language is because that's an adjudicatable pronouncement. In other words, if some physician just lies on a form in order to get an abortion, now the father or the grandmother or the grandfather can take him to task for wrongful death. And there's serious consequences for his insurance, for his licensing, for criminal code. And we might just say here that one of the things that we're going to need to do going forward is to make sure that the enforcement provisions for things like that are clear and adjudicatable and serious.
Yeah.
Oftentimes you'll notice that in good law, once the people who have opposed the good law have lost their argument, the last thing they do is try to take the teeth out of it. And that has happened an awful lot in Wyoming's abortion law. There's a lot of teeth that need to be reinserted as we go forward. So we kind of it's like an old man gumming his food, right? But let me get to the rape thing, unless you want to continue further.
No, you answered my question.
And health
I assume when it comes to the rape thing that it's quite similar. It's adjudicable.
Not quite. So here's the problem with rape, and the rape and incest exception was added at the very last minute on the floor of the Senate, and it was 24 to 25. No, that's wrong. 15 to 14, and the person who was sponsoring the bill wasn't on the floor at the time. It would have been 15-15, and it would have not made it. But it got in, and it's definitely something we're going to need to take out, because rape and incest exception was the first thing that started happening in the United Kingdom in the 1960s, and it was the camel's nose under the tent. Because what the rape and incest exception does fundamentally is it says there are some people who should be killed even though they're innocent. And once you've got that in there, it can go anywhere. And you are absolutely right that the biggest objection to the rape and incest exception is that it allows an open door for somebody to cry rape in order to get the abortion. And then because there's such a timely, it's rush, and you don't have time to adjudicate the rape charges before the window of opportunity for abortion closes down. And so judges are going to tend to rule on the side of the abortion rather than the truth of what's actually happening. So that's got to go away for a lot of different reasons. And I just want to say here, for the record, that the only longitudinal study that has been done on women who have conceived in rape and incest is published in a book titled Victims and Victors by David Reardon. And it's a fascinating read. I would just encourage all of our listeners to pick it up and read it. It is the thing which opened my eyes and made my argumentation for life what it is today. Because in the way that it's portrayed throughout the public is that the rape or that simply abortion and the rights of the child are kind of a balancing act. And so the rights of the mother to have an abortion versus the rights of the child to have its life, and you've got to kind of balance these. But when you look at the only longitudinal study that has ever been done on women who have conceived in rape and incest, there is a significant number of those women who regret it deeply that they got an abortion. And of that cohort that carried the baby to term and did not get an abortion, not one single woman regretted that decision. So the idea that it's better for the woman is simply untested and, as a matter of fact, proven the opposite. So when you are advocating for the life of the child, you are actually advocating for the best health of the woman too, mental and physical.
Yeah, absolutely. I mean, we're arguing for the happiness of mankind here, and that happiness, since we have a human nature that was created to love God and to know Him, that happiness consists in very concrete things. It is never good for a woman to kill her child, and that's objective. If we actually believe in a human nature. All right. The next thing I wanted to bring up is a political question. Not that a political question isn't also theological, that they always are. Everything's political. But a lot of political pundits are saying that the overturning of Roe v. Wade is going to energize the liberal base and bring all sorts of people out to vote for this pro-death position and get more Democrats into the House and into the Senate. And so now the midterms might not be such a slide one way toward the Republicans. And I mean, it's my personal opinion that the opposite will happen, but I'm a little bit of an optimist. I am going to be voting even more. I'm paying attention to my local elections for the first time, ever. and actually caring about them, studying who, the state senator is, what his position is exactly on abortion and so forth. I'm encouraging my wife to vote, right? I'm encouraging other people that I know to vote and giving them recommendations. And I just wanted to get your sense on how you think what this decision is going to energize each base, whether the liberal base or the conservative base.
I think there's going to be some energy in the liberal base, and we're seeing that in terms of attempted assassinations and illegal demonstrations. But I think your sense is more than simply empty optimism. I think your sense is spot on. That polling over the last several years, maybe even a decade, have proven time and time again that pro-life politicians win. That the vast majority of American citizens, and especially the vast majority of Wyoming citizens, want to see reasonable limits on abortion, if not it being gone altogether. So I think that I think it's going to be highly energetic, because in a time right now where there's a lot of questions about whether our vote even counts at all, we can now look at this political victory that have been prayed for and worked for 49 years and concretely see this was a giant step forward. And we can, by joining together, by praying, by paying attention to what's happening on a local and a federal level, we can affect change for the better. And I think that's going to be a huge energizing factor for us all.
I mean, ever since I've been voting, it used to be I would go in order to vote for, say, George Bush, or to vote for, well, I didn't vote for Romney because he's a Mormon. Plus, he was going to take Indiana anyway. Or to vote for Trump or whatever, right? That's why I went to vote for the national. And it's almost going to be reversed now. I'm going to go mainly to vote for my local representatives. And that is exactly how it should be. Not that we give up on the on the national, but that we get our priorities straight.
Right. That's right.
Yes.
And city council matters. And school board matters. Yeah, absolutely. And if we can get this message out that we need to stop obsessing about what's happening 2,000 miles away in a mosquito-infested beltway, and simply focus on our local elections, that's where the rubber meets the road, and that's where the Christian work with our neighbors to make a better world, that's where it matters most. Talking to the guy across the fence from you and about doings in your neighborhood.
All right. We got time for one more question. You gave me a couple of things to talk about here. The first one, I didn't even understand what you were talking about, so I'm not going to ask that question. The second one, it just went above my head. So maybe we can have another one of these and we can talk about that issue. There's plenty to talk about. But the second one was both the majority opinion and Kavanaugh's concurrence go out of their way to claim that the Constitution is completely neutral on the issue of abortion. So doesn't this require a judgment that the unborn are not persons under the 14th Amendment? And I noticed that, or at least that they might not be. I noticed that in the opinion itself, that the Constitution is neutral on the issue of abortion, and that kind of made my heart sink, because I was hoping, right, that the next step is to actually say, no, obviously the Constitution gives a right to life. It doesn't give, sorry, it acknowledges a right to life, and that no state should be able to, kill a baby, an unborn baby, especially not in the third trimester, as I think we're going to see more and more in states like California, Oregon, Washington. It's going to be devastating.
Yeah. Yeah. Yeah, absolutely. I think that the and I don't know. I mean, the people who signed the majority opinion, obviously they were trying to play some politics. I don't know how much they were convinced by their own arguments. But yes, they definitely said over and over that the Constitution is neutral on the issue of abortion. And every time I read that, either from Alito or from Kavanaugh, I was asking the question, well, wait a second, this entire thing, just to go back to the beginning of our conversation, when Casey threw away and stripped away all the arguments of the Roe court and boiled it down to the last argument of the Constitution they thought would hold, they boiled it down to the due process clause of the 14th Amendment, which reads, "No person shall be deprived of life, liberty, or property without due process of law." And so for the last 30 years, everything's been about that due process of liberty. And yet we have people being deprived of life without due process in the womb. And in order for Alito and company to say that it's neutral, you cannot count babies unborn as persons. And I think that's a huge correction that still needs to be made.
I think,
and maybe they were just, I don't know. I think they could have deferred that decision without saying so many times that the Constitution is neutral. I think that's damaging, and I think it's wrong, and I think they're going to change their
I think
minds.
if Scalia were,
The fact of the matter is that there
I
is
think if Scalia were still on the court, he would have made that exact argument that the due process clause assumes. I mean, this is in the Constitution. It assumes. If you look at common law, just the laws that were on the books at that time, that this right of due process is also accorded to the unborn babies. I mean, that follows from the historical arguments that Alito himself is making in the majority opinion, does it not?
That's right. That's what I see. I always think about Dred Scott. I mean, so Dred Scott, which is one of the most awful opinions the court has ever made, basically said that that a black person born in America is not a person. And what's fascinating about it is that after Appomattox and after the passage of 3 amendments, in order to fix all of that, and the shedding of the blood of 600,000 soldiers, I don't think they ever had to put in the Constitution that that black people are people. I think this, in matter of fact, this 14th Amendment simply uses the word person, assuming that the people who were freed from the Civil War fit that. So why do we have to have some theory of personhood which somehow includes babies? I don't get it.
That's exactly right.
Yeah.
And you know what? The Roman Catholics are really good at this, and we have to get good at it too, is that the entire fight for the rights of an unborn life, this flows seamlessly for the fight for the recognition of the worth of a black person. In other words, if you're going to make the argument that blacks should be accorded equal right because they're human beings, then you must also make the argument that unborn babies are so. All this is another class of people that have been oppressed by Democrats in the United States. That's history.
Yeah. Well, and right, and it also, this whole thing, it really is a new religion, not a new religion, a very old religion, right? So Gnosticism is what we're seeing here, and it's across the board. Of course, it's in Obergefell and everything else that's been happening, the Bostock and the rest. But basically what you have here is that this Gnostic religion wants to put daylight between a human being and a person. And there is no daylight. between a human being and a person. And if we grant that for the sake of argument, we've lost the game. And I'm afraid that's going to be something that has to be corrected, that the court has to come out and say again, there's no daylight between human being and person. That's a religious tenet.
Exactly. Yeah, of a false religion.
And a false religion.
It's hilarious and tragic that this distinction between religious and secular is even still made, because obviously they're following their religion and then telling us that we can't follow ours, and that's just not the way it goes. We have to be historically minded people and realize that we've come from a certain culture. Certain words and concepts are defined by our history, and you can't just abandon it. And so, like, the appeal to common law that is all over in this majority opinion is exactly the sort of classical mindset, conservative mindset that we need reinstated in our public discourse. Because otherwise, there are no definitions. There's no definitions of virtues. There's no definition of a human being. There's no definition of our common good, of society, anything. It's all anarchy, and it's all then given to the horribly liberal religion of justices like God has given me a blank in my head, not even to remember their names. Thank you. What are their names? Go ahead. Yeah. Thank you. Sotomayor, Kagan, and
Kagan,
and Stevens, right? Or Breyer. Yeah, Stevens is gone. Yeah. So, I actually do. Thank God that he made me forget their names momentarily. Okay, we are all out of time, Pastor Lange. This has been just wonderful. I've learned a lot, and I hope our listeners have too. I'd like to have you back again soon. I'm going on vacation for a bit, but then maybe after that, end of July, I'd like to have you back to talk about how we actually engage our community for pastors, lay people, and so forth, while still holding to our Lutheran confessions and our Lutheran principles. Because I think that's very important, and we have to do more and more of it. We have to go out into the community, but we also have to remain faithful to our Lutheran confessions. And the zeal to spread God's kingdom includes, obviously, the preaching. It is the preaching of the gospel, but it involves other things. And that means getting involved in our community. Thank you so much. That'll be our next topic for our podcast. Thank you, everyone, for viewing. You can visit our website at www.lutherclassical.org. And until next time, God bless our families, God bless our congregations, God bless Luther Classical College.
God bless you all. Thank you, Pastor.